So first, we will discuss Christine Chabot's entering the Unitary Executive. And you guys have already been in the sessions too, but we'll have 12 minutes for Christine to tell us about her paper. I'll offer some comments. I don't know if we'll take up all the 12 minutes, but then we'll leave it open, and we've got some discretionary time too to do with whatever we please. So take it away.
All right, thank you so much. It's wonderful to be presenting here. And as mentioned, this paper comes not to argue with the Unitary Executive, but it comes to bury it. And in this paper, the comprehensive historical record that I have unearthed shows that the founding generation never understood a unitary executive president to be part of our Constitution. And of course, by unitary executive, I am talking about the president's power under Article 2 to control subordinate officers. And the unitary executive theory is summed up, I think, most elegantly by Justice Scalia in his dissent in Morrison versus Olson. And he says, basically, the president must have plenary removal power in order to ensure that she has exclusive control over all subordinate officers who are exercising executive power. And this, of course, has huge ramifications for today's administrative state, both at the top level of independent agencies like the FTC, as well as inferior officers like administrative law judges. And the problem I have with this argument is that its supposedly originalist foundations are weak. If you read the text of the Constitution, the starting place for all originalism, there is no express presidential removal power in the text of the Constitution. And likewise, the history that a lot of scholars in the Supreme Court has relied on is limited. The history here is really based on the decision of 1789, something that was talked about in panels earlier this morning, and 3 statutes that came after that. And I'll just turn quickly to some screens to share with you. You guys all see these screens all right? You're good. I'll go to my next screen. Is really my project is to extend that understanding of looking to, what did the first federal Congress reflect in its understanding of the Constitution when it set up the initial regulatory structures of the United States. And I went and reviewed not only the decision of 1789 and those initial 3 statutes, but I looked to every public act that was passed by the first Congress. And what that shows me is that history tells a different story than the Unitarians say that it does. And my thesis is that the overwhelming number of regulatory structures we had at the founding were just as non-unitary as many of the regulatory structures that people are arguing about today. And what I'll present for you today are just some high-level overviews of what I think is some of the most compelling historical evidence from my research. So, first example of a case where Congress departed from the unitary model are cases in which it didn't rely on removal, but instead used multiple officers to check one another. And especially in the area of revenue, the first Congress doubted the president's power to control a single Secretary of Treasury who might be inclined to embezzle money. And part of the reason for that lack of confidence in the president's ability to police the Secretary of Treasury is the way that early revenue collection would be set up. The idea was to collect revenue through customs duties that were collected on imported goods coming into some 50 seaports on the coast of the United States. And it would be very difficult to tell whether the secretary was conducting his office honestly or was embezzling money, given the kind of spread out nature of this revenue collection. So the solution that the first Congress adopted was to make sure in the Treasury Department that the Secretary of Treasury never himself laid hands on the money in order for money to come into Treasury that was collected as part of the revenue collection. Two other officers, in addition to the Secretary of Treasury, had to sign off and agree to that intake of money. And by the same token, anytime anyone in Treasury wanted to disperse money, the Secretary of Treasury had to countersign a warrant with the Comptroller of Treasury, and only then could the treasurer actually disperse the money according to law. In addition, when the first Congress set up more discrete executive officers to collect revenue, the customs collectors who would man these ports where people were bringing in imported goods upon which duties would be charged. At the bigger ports, so Philadelphia and New York, they imposed a requirement that two officers always sign off on records of what goods were imported, as well as the total amount of duties collected to ensure that there weren't incentives for bribery. So again, these officers checking one another, and not the idea of a presidential removal power. What was really governing how these officers executed their offices and had faithful execution of the law in these cases. The second example here of multiple officers who here checked the president and each other was the Sinking Fund Commission. And the Sinking Fund Commission was Alexander Hamilton's brainchild. And basically the problem here was that neither Hamilton or the first Congress could trust the president or any other politically accountable actor to use money that was set aside to repay the debt for that purpose, rather than turning it aside to some other more politically expedient use. So the solution here was to make sure that any time the president wanted to use money to pay down the debt through open market purchases, that decision had to be approved by a 5-member sinking fund commission. So the president alone was powerless to effectuate this disbursement of funds. And again, the Sinking Fund Commission was independent, both in its membership. It included Chief Justice John Jay and Vice President John Adams, in addition to Alexander Hamilton, Thomas Jefferson, and Attorney General Edmund Randolph. So you had some independent members, but the removal power wasn't really something that the president could use to shape this commission's decision. If, for example, the president disagreed with a vote cast by Thomas Jefferson and wanted to remove him for that reason, that would just shift the majority vote on this commission over to one of the independent actors. The third vote would be Chief Justice John Jay or the Vice President John Adams. In addition, just the multi-member structure itself lent itself to disagreement even amongst cabinet members. So in 1792, there was a famous policy dispute between Hamilton and Jefferson ultimately dissented from disbursement of funds for debt repayment that was approved by both President Washington and Hamilton. So that's a second example of areas where Congress relied on these multi-member structures to ensure that the law was complied with and did not just turn it over to the president's removal power. Second set of examples really reflects the fact that the president alone was not the one who was or had exclusive power to police how executive officers carried out their duties in office. And in these particular cases, again, a big concern was that a lot of law execution was conducted at these very discrete locations, these ports scattered at 50 different locations along the coast of the United States. I have a picture of one of the ports from Philadelphia. And to police and make sure that the collections officers at these ports were honest and were not taking bribes in order to allow people to smuggle imported goods into the country, the mechanisms that the first Congress used relied on non-removable judges and laypersons. So first of all, these collections officers had to post bonds and have private parties post bonds in very large amounts of money to guarantee the collections officers' faithful execution of office. In addition, there was the possibility, if an officer did take bribes, that they could be sued and a judge could force that officer to pay fines. And in some cases, the judge could also actually remove that collections officer from their office. In addition, in some cases, private parties could also bring actions in debt to enforce faithful execution of the law. So, for example, if a marshal who is supposed to go out and collect the census information shirked his duties, he could be sued, and the private party suing could recover part of the fines assessed against that marshal for failure to carry out the role of his office. Similarly, in the area of customs collection with respect to whiskey, at least, there were areas where private parties could bring actions in debt against collections officers who either abused their office or took bribes. So again, here you have a situation where it's not the president exercising exclusive control over how executive officers are carrying out their work. There are private non-removable actors and judges who are supervising this work as well. Final example here is just the fact that the first Congress assigned discretionary executive decisions to non-removable actors. And we saw this a little bit in the Sinking Fund Commission, where Chief Justice John Jay and Vice President John Adams cast votes on executive decisions in those cases. And in addition, there are other areas where the first Congress required, in some instances, for revenue collection and the idea that someone would have fines to pay if they didn't pay all of their proper duties. There was an action for remitting or reducing those fines that were required to be paid. And the initial decision maker in those remission determinations were federal judges. They would decide whether there was evidence or not of intent to violate the customs laws, and that finding of intent would form the basis of a decision of whether or not to remit or reduce the amount of fines that they had to pay. So overall, in looking at all of this evidence, I come to the conclusion that early regulatory structures simply did not give presidents exclusive control or plenary removal power over officers who were executing the law. And the supervisory power that President Washington held at the founding was not materially different than the supervisory power that presidents today have over many of the regulatory actors in our system. And I will slightly over time, so I will stop there.
Okay, great. Thanks, Christine. So it's a little bit of ambiguity in the instructions. I think instead of doing all three presentations and then talking for 12 minutes, I'm just going to do my comments after each presentation just for about 4 minutes, because I just think that probably just makes more sense. Okay, so I thought this was a really terrific contribution in a number of different threads of literature. Of course, there was the long-running literature and debates about the Unitary Executive, but then also this more kind of recent set of efforts to sort of hoist originalists on their own petard and kind of introduce originalist arguments against some of the originalist claims. So the first kind of comment that I wanted to put on the table was just which flavor of the Unitary Executive theory is your target? Because of course it comes in many flavors, right? And I think that your main target, the one that you're interring, is the one that is the most absolute and what you might call like the exclusive camp. That is to say that the president has like the exclusive executive authority in the end, absolute removal power. And I think that there are a few people in this camp, scholars mostly, but I think there's also another flavor of unitary executive theories, which allows for more exceptions and carve-outs from this absolutist view. I mean, so if you even take just kind of the current jurisprudence reigning in the Supreme Court, some of these exceptions, as you know, are exceptions for inferior officers, right? For offices with limited duties and no policy-making authority. And I think it's less clear, I think, whether your findings would inter or bury or confront this other flavor of unitary executive theory. Okay, I'm getting a chat that my bandwidth is low. Maybe I'll turn my video off. That'll help. Can people hear me? That's better. Okay, I'll just do it verbally then. Okay, so that's the first thing. So maybe it would be worth making clear kind of which version of unitary executive theory you think that you are burying. And on that, I have a whole set of thoughts on how this other camp, that is the partial Unitarians, if you will, would respond. And I think that they would find your evidence less persuasive. For example, I think this camp, insofar as they focus on the removal power as the main indicia of independence, I don't think that they would buy your kind of Revez-Dahl-esque move to talk about other indicia of independence, such as the multi-member structure and so on. So it's revealing that I think some of the Unitarians respond to your sinking fund commission example to note that 3 of the 5 members were removable at will. In other words, you're just not going to get them on. They're not just not going to be convinced, you know, by some of your examples. I think you provide a really nice functional response. You know that you say, of course, that it transfers, the power transfers to a different controlling third vote, but I still don't think that those that focus on the removable power would really be convinced by that. Relatedly, in terms of kind of whether they would be convinced by this evidence, I wonder if you could say more in the paper about what exactly is policy-making authority. And in other words, how you think this evidence fits into that exception or confronts it. So for example, many of your the statutes that you found deal with grants and disbursements of funds. And I think that there is a conception of policymaking authority that would not count that as policymaking authority. I mean, of course, like Eloise Pascoff would say, of course it's policy, but I think that there is the old kind of rights versus privileges view. That is to say that these grants are just like benefits, the largesse of the government, and policymaking authority, by contrast, bears more on effects on third-party rights, you know, in the old due process sense. So I think it's worth saying a bit more about that. Similarly, or you know, on this front of fitting into these exceptions, I think many of the examples of the statutes that you found are seem like those that could be the kinds of duties exercised by employees rather than inferior officers. So I'm not even talking about inferior officers versus principal. I think many of these are just employees. So for example, things like appraising goods, right? You have examples of statutes where judges are summarizing and transmitting findings, or they're making inquiries. I mean, these seem like duties, again, that are exercised by employees. And as you know, and the Supreme Court has said repeatedly, you know, they're fine with removal restrictions on employees in the civil service, you know, as far back as Myers. And then also similar, I think another carve out here is adjudicative decisions. You know, many of your examples are adjudicatory in nature, especially when they deal with fact finding. Arthrex even appears to kind of carve this out. And so I think some of the reigning kind of unitary executive ish people on the court, I think, would not be convinced by these that these findings effectively rebut them. Just a final word on just exposition and style. I thought I would suggest putting your main contribution before all of the wind up and the summary of the Supreme Court precedents and all of that, because I just felt like it was just too much wind up. Like I just wanted to kind of get to your new findings and contribution. So I would, and then, save that part for later after you've given us the contribution to sort of reflect on the implications of your contributions for Supreme Court precedent. And finally, I'll just say, I thought it would be worthwhile making even clearer kind of the novelty of the contributions. I'm absolutely convinced that you found really new, interesting historical evidence. But from your exposition, it seems like some of these statutes were known to the unitary executive folks. For example, the power sharing statutes you say were dismissed by Calabrese and you as isolated deviations. So like they knew about these statutes, right? So, which ones did they not know about? Did they know about? It would just help give the reader, I think, a greater, more clear sense of sort of what the kind of new historical evidence that you've unearthed is. All right, those are some, I have more to say, but I know there's a lot of folks in the room that would have interesting things to say as well. So we'll open it up to discussion at the end. All right, so with that, let's move on to Gerard's paper. So Gerard Maglioka is going to talk to us about Robert Jackson's non-delegation doctrine.
Okay, thank you, Voice of Jennifer, and thank you to everyone in attendance. So my paper talks about Robert Jackson's view of the non-delegation doctrine, which was that there was a constitutional limit on direct delegations to the president over domestic affairs, but that there was no such limitation for congressional delegations to executive agencies or independent bodies. And the cash out of this argument is that you can make a constitutional claim against the National Emergencies Act, at least as applied to domestic affairs, because it delegates broad emergency authority directly to the president without any meaningful limits and in a way that's inconsistent with Jackson's analysis in his concurrence in Youngstown. Now, I should say at the start that this project is kind of a surprise to me. I am not an administrative law scholar. I never thought I would write a paper about the non-delegation doctrine. And indeed, I think the chief weakness of the paper is that I do not know as much about administrative law as I need to kind of fully theorize some of the things that Jackson was talking about. That said, so why did I write this? Because I just decided to read Jackson's briefs from when he was Solicitor General, because I was just curious. And the most interesting brief of all of them was in a case called Curran versus Wallace, which was kind of a nondescript New Deal type case about a law regulating tobacco. But in that case, there was a non-delegation claim, and Jackson responded to that claim in part by offering up a broad theory of the non-delegation doctrine. And it makes for very interesting reading. And so one thing that I think the paper contributes is just to highlight this and bring it to the attention of people, because no one seems to really looked into it much after the brief was submitted. The court did not comment on Jackson's theory at all in its actual decision in the current case. So I'm going to skip over Jackson's explanation for why there was no non-delegation doctrine for agencies and independent entities, because the interests of time partly, but also because it's not as interesting probably as the other aspect of Jackson's discussion, which was that there was a limitation in his view on Congress's ability to delegate power directly to the president over domestic affairs. Foreign affairs was left aside as something without a delegation limit because of the court's holding in the Curtis Wright case. Okay, so why did Jackson say in this brief that he thought there was a delegation limit on direct delegations to the president over domestic affairs? Well, it was surprisingly for Jackson, it was a kind of formal answer. One was, well, Congress cannot give legislative power to the president. It's simply a separation of powers matter. And those categories are mutually exclusive. So that was one argument that he made. A second argument was that, well, if you look at Panama Refining and Schechter Poultry, the two non-delegation precedents that he had to deal with, he said, well, they both involve direct delegations to the president under the National Industrial Recovery Act. And so therefore, we should understand there to be a delegation limit when Congress delegates power directly to the president, but there isn't a precedent for anything else. So it was more of just a kind of, let's look in particular at these holdings and what was going on in those cases. Now, I mean, the paper tries to advance at least some justification for why you might think direct delegations to the president are different from delegations to agencies, in part simply on the grounds of Congress having somewhat more control over agencies or independent entities than over the president himself. Let's say budgetary control, political influence, control over nominations and appointees, and so on. But Jackson never really offered any kind of explanation for this distinction that he was making between agency delegations and presidential delegations. Okay, so the reason that all of this matters is not just because we like Robert Jackson and we care sometimes about what he thinks. It's because this same reasoning is in his analysis in the concurrence in Youngstown. So if you go and look at his opinion there, and you look at the three categories, right, that you're all familiar with, in category one, right, Jackson talks about this being a circumstance where the president has maximum authority, when Congress has expressly authorized the course of action the president wants to take, right? Now, sometimes this is taken to mean that, well, if it's something's in category one of Youngstown, it's lawful unless there's some prohibition somewhere that prevents either Congress or the president from doing something, say violating the First Amendment or something like that. But this is incorrect because Jackson quite clearly refers to all the power that Congress can delegate to the president. And then he has a footnote in which he talks about the non-delegation limits that there are on direct delegations to the president. Youngstown, of course, being a case about the president rather than about an agency as such. Now, Youngstown being such a canonical opinion does allow for some latitude in digging around a bit more. So, I mean, I went into the drafts of the opinion that are in the Library of Congress, and of course found that Jackson, in fact, in earlier drafts had expressed citations to Panama Refining and Schechter Poultry in this section of the opinion when he was trying to articulate what Category 1 was. Then he just removed some of the cites and he left just the textual language describing this kind of non-delegation doctrine for the president. Okay, so the brief in Curran tells us he thinks there is a non-delegation doctrine for direct delegation to the president. Category 1 of Youngstown confirms this. Okay, but really two questions then. One, how often does Congress delegate power directly to the president? And the answer is, well, there are a fair number of them, but a lot of them are kind of innocuous or hemmed in pretty well, don't really raise any particular concerns. But the one exception to that is the National Emergencies Act, which of course people are familiar with because it was used during the Trump administration especially, and that delegates a whole lot of powers to the president merely on his say-so that a national emergency exists. And the only way that Congress can countermand that is by, in effect, passing a resolution over the president's veto, which has never happened since the National Emergencies Act was enacted. So it's this very broad delegation without any particular limits in it, at least as it's currently constituted. Now, well, how does that affect this non-delegation analysis that Jackson put forward? Well, the answer is, you can say that emergency authority is quintessentially legislative and quintessentially non-executive. Now, how do we know that? Because Jackson says so in Youngstown itself, right? A good deal of the discussion in the opinion is about how the president doesn't possess emergency power, only Congress does, and that Congress can delegate such power to the president. But then when you look at what Jackson says about such delegations or the examples that he uses, you see that they are rather different from the National Emergencies Act in a couple of respects. First, Jackson emphasizes that congressional delegations of emergency power to the president are temporary, right? And of course, the delegation under the National Emergency Act is not temporary. It lasts for pretty much as long as the president wants it to last. Secondly, a lot of the examples that Jackson refers to in Youngstown of emergency delegations to the president were on a much tighter leash than the National Emergencies Act delegations are. For example, Congress had to declare war, or Congress had to specifically declare an emergency to unlock the particular power that the president wanted to exercise in proximity to the congressional delegation. And thirdly, we know that some of the examples that Jackson referred to or were thinking about in his Youngstown analysis had a legislative veto in them. We know that because it's in the drafts of the opinion, and we know that because Jackson, instead of putting that material into the final opinion, decided to publish an article in the Harvard Law Review a year later, where he just talked about his views of the legislative veto and his disagreement with President Roosevelt about whether legislative vetoes were constitutional. Now, in other words, Jackson sort of the backdrop for his idea that yes, Congress can delegate emergency power, this legislative power directly to the president, is hemmed in by, okay, temporary, tighter leash, and the idea that a legislative veto is there, at least when the power is significant. Okay, none of that really lines up with what the National Emergencies Act has in it now, especially post-Chadha, because the original National Emergencies Act had a legislative veto in it. Now it doesn't, of course. And all of this creates a certain constitutional vulnerability to the statute as applied to exercises of power over domestic affairs. Now, this is not to say that necessarily a challenge to the act would succeed in an as-applied situation because, well, you'd have to say, well, why was it exercised? What is the justification, and so on. And what power in particular are people contesting? My goal here is a little more limited. It's to say that, well, you can make a credible non-delegation argument against the act, as well as other examples of emergency power. And then the sort of flip side of that, which of course I've kind of glossed over in the talk here, is that, well, okay, that is the non-delegation doctrine. So there is a non-delegation doctrine, but it only applies to direct delegations to the president, which is of course contrary to kind of most of the discussion of the non-delegation doctrine that we typically see. So maybe I will stop there, except maybe to just say that this is part of a broader project I'm working on. It's going to be a book about Jackson's Youngstown opinion. So that's sort of how I'm trying to fit this into what I'm thinking about. So maybe I'll just stop there.
Great, thanks, Gerard. So I'm going to try this again with my video on, but feel free to chat at me if there are problems. Okay, so one of the many interesting theoretical claims of the paper is, just as you said, that Article 1 limits delegations to the president, but not executive agencies. And so, of course, naturally, and I think this is the admin law kind of radar maybe, it begs the question that's raised in the whole Kagan versus Stack debate about, how do we interpret statutes that identify the president explicitly as the statutory delegate versus in an agency head or a secretary and so on. And as the Kagan view says that specifications of an agency head were implicit delegations to the president. Okay, and then Stack shows that there are mixed delegations. He basically contests that view. But I think the premise of your paper, or at least the reconstruction of Jackson's theory, seems to reject that view. That is to say, there's some meaningful, that a delegation to an agency head is not the same thing as a delegation to the president. And I think that your paper needs to either reconstruct Jackson's view, or when you take a more presentist kind of argument, tell us kind of what you think about that. As is well known in that debate, that the view that Jackson seems to be holding here is in tension with the other congressional actions, such as the Presidential Delegations Act, which shows that Congress never contemplated that the president would actually be the one to exercise this power. In any case, that's a kind of a broad thought. Three other main buckets. Okay, and I think all of these comments depend on what genre you see your paper fitting into, and it can fit into multiple. But I think that question informs, how far you want to take some of these thoughts. Okay, so one genre of this paper could be that is an exercise in historical recovery. You've recovered, a brief that nobody's really thought much about, and that this brief can shed light on either understandings of the non-delegation doctrine in 1938, and therefore present alternative possibilities for us today. And in this genre, there are some veins in the paper that could be telling us about, like, what is Jackson's theory of non-delegation. And if that's kind of the way we should understand this paper, what should we make of the fact that he was serving in a particular role when he wrote this brief? Okay, so everyone knows that where you stand depends on where you sit, right? Like, I think we need to think about, like, how are SG briefs drafted, right? I mean, certainly they're not just Jackson's view, right? It's a deliberative process in the office. And we also need to think about the incentives of the SG in the office. For example, his brief continuously refers to the challenges or the burdens, rather, on an SG's office that has to continuously defend these statutes against non-delegation claims. And so, of course, there's an incentive to narrow the non-delegation doctrine from the SG's perspective as only applying to those of the president. So, so that's kind of one thought for why this might not just be Jackson's theory. And then on top of that, of course, his views could have evolved from 1938 to when Curran was written to the book project that his book, Jackson's book in 1941, all the way to Youngstown in 1952, right? I think that it's very possible that by Youngstown, where he doesn't really explicitly, the footnotes and the references to Curran are there, but he doesn't mention it, and even the book references are oblique, so it's not clear, that he still held this view. And then as to kind of the second bucket of looking at the theory, Jackson's theory, just on its own terms, forget historical recovery, just on its own terms. There's the usual questions that arise here of, is Jackson's theory, is it just atextual? I mean, like, how do we get from the word legislative in Article 1 to a meaningful difference between, a statutory delegate as the president and the agency head? Do we just say it's an atextual theory? Does his theory have anything to say about what kinds of delegations to the president would be unconstitutional? So you suggest that, for example, anything that was an emergency power is a legislative function, but it wasn't clear to me, like, why this was the case. Like, was this the case simply because they can be too broad? This is kind of Justice Thomas's view of the non-delegation doctrine, or is it because that, they always lack intelligible principles, which doesn't seem to be necessarily the case? I didn't understand, even from Jackson's own theory, kind of what the limits of delegations to presidents would be. And then relatedly, I wondered if the theory had anything to say about the delegations to agencies. Your reconstruction of Jackson's theory seems to suggest that it could be much more capacious, but then, like, how far does this go? For example, would we expect, like, would he accept the Posner-Vermeule view, speaking of enduring doctrines, that, that Congress can basically pass any statute as long as it's not literally allowing executive agencies to, like, vote on bills. It's a very formalist view of the non-delegation doctrine. So I just didn't know, obviously Jackson probably didn't have a theory, honestly, but if this is going to be a project about reconstructing the theory, I think, it'd be useful to say something about these features of the theory. Finally, on this kind of part, I didn't understand this argument that if part of the rationale is that delegations to agencies are revocable, and that's the meaningful difference between agencies and the president, like, I didn't quite understand why the delegations to the president aren't similarly revocable. If it's that Congress has more tools of control over the agency, that seems like a different theory than revocability. Okay, finally, in the interest of time, the third bucket, which is kind of the more, what you might call presentist implications, because you're trying to draw something from the brief in Youngstown to the present day. I thought there was a really deep question here about what tools of judicial interpretation, that, let me be clear, the tools that we should use to interpret judicial opinions should be. How do we interpret judicial opinions like Youngstown? Okay, so there's a really interesting literature here. Aaron Vermeule has written this wonderful article that many of you know about judicial history. Like, should we look beyond the face of the text of the judicial opinion into the judge's own files and mind? Are those valid tools of interpretation? And your paper implicitly seems to argue that a brief written by the judge in a different case 20 years ago should somehow be a tool of interpretation for interpreting Youngstown. And that's arguably not how we ordinarily interpret judicial opinions, right? I mean, you could say that we're textualist about judicial opinions. That is, we look at the actual words of the opinion itself. And do you mean to, how far should we take your interpretive suggestion implicit in the paper here? Finally, as to the presentist opinion, bringing all of these to the National Emergency Powers Act, I think you seem to think that it's unconstitutional on separation of powers grounds. It was just less clear to me about how the non-delegation concern would strike it down without an independent theory about what kinds of presidential delegations are unconstitutional. For example, this act seems to have an intelligible principle. Without more in the theory to evaluate the act, I didn't know if Jackson's theory by itself really had much to say about the particular act itself. So in short, I think that there's a lot in this paper. I think it's a wonderful historical contribution, and I think it would be strengthened even more by some thinking about kind of the implications of its premises. All right, with that, and an eye on the
Hey,
clock.
thank you.
Yeah, and then, we'll talk about how we want to use our 20 minutes, but obviously I'd love to give the presenters a chance to respond to all the audience's comments and any that I offered as well. Okay, so with that, let me turn it over to Bijal Shah to talk to us about a critical case against administrative functionalism.
Thanks, Jennifer. Hi, everyone. It's good to see you. Thank you for taking the time to attend. Thanks to U of A for gathering us in this way. However, they could, if not in person, then Zoom will certainly do. Currently, scholarship in structural constitutionalism and ad law discusses norms in narrow and limited ways. And as we know, the center of debates concerning structural constitutionalism is formalism, and functionalism is the response to formalism for those who value effectiveness, flexibility, and outcomes above adherence to originalist or textualist principles. So Peter Strauss, for instance, has characterized functionalists as, quote, freer of dictionaries and more attentive to evidence of the concrete social issues catalyzing legislative action than formalists often are. This paper is not a critique of formalism in the vein of terrific recent scholarship that identifies methodological and theoretical flaws in originalism and textualism. That work is very important, but my paper takes aim instead at functionalism. More specifically, I focus on deconstructing the idea that functionalism is a bastion for those who seek to optimize social or distributional outcomes of administration. Functionalism is not a panacea for anti-subordination, equity, or social progress. Functionalism, like formalism, has the capacity to result in harm. And it's moreover not the case that functionalism simply does not function as it should, no pun intended, or that it does not prioritize outcomes in a manner that is in keeping with its commitments. Rather, functionalism's fundamental commitments may be antithetical to equitable outcomes. So more specifically, the problem with functionalism is that it emphasizes, this is my argument, that the fundamental interests that administrative institutions have in self-preservation and proliferation over the interests of the people that agencies are tasked with regulating. It's the essential nature of functionalism, again, its emphasis on the self-interest and preservation of administrative institutions, that is precisely why it's ill-suited to benefit people. Okay, so now that I've introduced my argument, let me tell you how my remarks will proceed. First, I'll elaborate on the premise that functionalist mechanisms in the administrative state harm the interests of vulnerable and marginalized communities. To substantiate this assertion, I'll focus on three significant aspects of functionalism. I'll highlight harms wrought by the exercise of administrative discretion under our functionalist non-delegation doctrine. I'll discuss some drawbacks of congressional oversight of administrative action under a functionalist understanding of the separation of the political branches. And then I'll discuss some of the problems of independence in administrative adjudication, which is again fostered by the functional view that administrators should be insulated from political influence. And then finally, I'll talk a little bit briefly about how separation of powers theory might respond to these flaws of functionalism. The answer, I should say up front, is not the formalist call to deconstruct the administrative state. That's not what I'm advocating for. Rather, I think that administrative action can be improved by recognizing that functionalism is driven essentially by administrative self-interest. And this fundamental insight that functionalism is motivated by institutional self-preservation creates an opportunity to both constrain this administrative instinct and to replace that instinct with better incentives, including a focus on protecting instead of subordinating vulnerable regulated communities. I think this talk should be around 12 minutes long, maybe 13. I'll try to talk fast. Okay, so leading theoretical approaches to the separation of powers assume that unlike the Equal Protection Amendments, the structural provisions of the Constitution don't require a moral philosophy in order to be coherently interpreted or applied. There are many thoughtful scholars that have begun to unearth inequity fostered by the federal branches in the administrative state. We have Blackhawk and Milligan illustrating that institutions and agencies foster racial subordination. We have an emerging literature on the distributional consequences of regulation, including cost-benefit analysis from scholars like Ricky Revesz and Daniel Hemmel. But the dominant theories of constitutional structure, namely formalism and functionalism, have yet to be deconstructed, let alone evolved to improve how interbranch dynamics may confront, subordination and systemic equality. So as I mentioned earlier, I look at functionalism in this paper. Functionalism's worth is often based in its capacity to acknowledge and stave off the real world outcomes that might flow from formalist conceptions of what constitute an ideal separation of powers. So in Robert Gordon's influential work, he explains that functionalism's goal is to peer behind and ultimately discard formalism's abstractions in order to find, explain, and make law relevant to realities that lurk in the knowable world beyond the foggy mists of formal legal doctrine. Okay. But functionalism also, I think, lacks, despite its sort of positioning as responsive to formalism, it lacks, or maybe because of this positioning, it lacks a clear social theory. And so to me, unadulterated support for shared duties among branches of government and for powerful administrative agencies is unsatisfying. A functional approach to the separation of powers does not guarantee that agencies will manifest equality or equity. And moreover, functionalism can be harmful, can lead to outcomes that injure marginalized communities. So let me offer some examples to substantiate this claim. One context in which I offer a critique of functionalism is in the realm of administrative discretion. Speaking of Justice Jackson, he suggested that nothing opens the door to arbitrary action so effectively as to allow officials to pick and choose only a few to whom they will apply legislation. Unrestrained administrative discretion has led to problematic outcomes for communities based on race, religion, criminal, or citizenship status. So in the national security context, Shireen Sinar shows that as an institutional matter, the governmental treatment of international terrorism leads to more severe punishments against racial, ethnic, or religious minorities than those faced by domestic terrorists. Nermeen Arastu illustrates how the administrative review of citizenship applications and petitions for national security review has in fact resulted in systematic bias against Muslim applicants, primarily so that administrators can prevent a lengthy and extensive external vetting process. In the immigration setting, Isha Jain argues that the discretionary use of arrest records renders immigration enforcement overly punitive. Gerald Newman says that systemic disadvantages for certain populations subject to discretionary deportation practices have been exacerbated by the events of 9/11. In crisis management, David Super attributes many of the public failures for certain communities after Hurricane Katrina to excessive or inappropriately exercised agency discretion. Environmental justice, Sheila Foster shows that administrative choices for industry siting determinations, which are discretionary, often result in hazardous waste facilities being built near poor and minority communities due to the bureaucratic ease with which such facilities can be built in those communities. I also think it's worth highlighting a sort of recent controversy concerning whether or not notice and comment should be more accessible to marginalized communities. So rather celebrated functionalist Dick Pierce takes issue with the idea of rulemaking as a plebiscite and disparages comments that don't supply data or reasoned analysis. Now, this perspective is so concerned with agencies' interest in maintaining their own legitimacy that it excludes, as Nina Mendelsohn has put it, situated knowledge reviews that could be relevant, useful, and even important to many rulemakings. Another aspect of functionalism that I think is ripe for critique concerns the harms and limitations of legislative oversight. So the INS versus Chadha case from the early 80s, it deemed unconstitutional and eliminated the legislative veto. This was a very formalist decision, right? And in any case, soon after Chadha was decided, functionalists began to advocate for the legislative veto to allow Congress to better oversee its vast system of administrative action and discretion. But this position too has its faults. Legislative oversight via veto or otherwise is a mechanism by which Congress can force agencies to implement private interests or the legislature's own biases. So as Cass Sunstein has suggested, the legislative veto itself is a tool for agency capture by powerful interest groups. He notes that the legislative veto aggravated the problem of factionalism, the very problem it was designed to solve, and that it provided well-organized private groups an additional opportunity to fend off regulation. Second, a sitting Congress may expect agencies to pursue its own political interests. So as Thomas McGarity has observed, congressional oversight committees acknowledge few restrictions on their powers to force agencies to take actions that may or may not be consistent with the statutes enacted by prior Congresses. So this approach has led to concerning administrative outcomes in immigration, criminal enforcement, and national security. As to immigration, it's noteworthy that the veto in Chadha itself would have overturned the Attorney General's suspension of deportation after only an unfair and inadequate legislative deliberation. In the federal sentencing context, Rachel Barco argues that Congress has greatly interfered with administrative efforts to temper the trend toward increasingly longer sentences, particularly when reducing the length of sentences could improve the biased impact that criminal sentencing has on people of color. And in the national security and post 9/11 context, for instance, Aziz Huq says that the political pressure that Congress faces is especially strong when it comes to counterterrorism. And so he argues that pressure often moves elected officials to push agencies away from optimal policies, and that legislators tend to be more pro-security than pro-liberty, and sometimes even run campaigns on harnessing agencies to invade individual rights as a signal that they're tough on terror. One more example or situation in which, or aspect of functionalism that would benefit from a critical perspective is decisional independence in administrative adjudication. So, again, functionalism argues for independence, but decisional independence and discretion in adjudication has led to biased application of the law. So my own previous work has shown how administrative adjudicators may privilege the government's interests along two dimensions. First, by advocating or deciding in favor of institutional interests, and second, by making decisions that comport with regional idiosyncrasies and adjudicators' own personal skepticism. And then I do think it's also interesting to perhaps engage with a sort of neo-functionalist idea that was raised by Adrian Vermeule and Ron Levin a couple of years ago. So in a paper published in the Harvard Law Review, Vermeule argues that a couple of years ago in 2016, he argues that courts should defer to agencies' assessments of administrative due process. And then Ron Levin, a functionalist if there ever was one, suggests that perhaps while the idea of extending Chevron to agencies' determination of what process is due is perhaps impractical, that nonetheless courts might limit their intervention in administrative due process to the margins, even as a matter of constitutional law. So really, both Vermeule and Levin's positions are blind to the fact that agencies are likely to engage in self-interested Matthews and Eldridge versus Eldridge calculations, and that reducing judicial review may exacerbate deprivations of due process. Okay, so what to do about this? I only have given myself a minute to talk about that, so I'll just give you a brief overview, and I'm happy to go into greater depth in the Q&A. But as I mentioned in the beginning of my remarks, the Achilles heel of functionalism is that it emphasizes the self-interested views of administrative institution or values, excuse me, the self-interested values of administrative institutions over the interests of the people that agencies are tasked with regulating. Again, I don't think the answer lies in dismantling the administrative state. Rather, if the problem with functionalism is that agency actions are too aligned with their own institutional interests, then the solution may be to develop a separation of incentives, right? One that divorces agencies from their conventional institutional concerns, namely that reduces their interest in concentrating discretion, acting flexibly, engaging certain political priorities, maximizing efficiency and conserving their resources, right? These traditional functionalist values, and shifts them or changes them to better protect subordinated and vulnerable communities. There's a couple of ways we might skin that cat, just to take 20 seconds or more or so. We might look to institutional design, bureaucratic design. We might look to ways to reduce the impact of sitting Congresses on agencies. And again, I have thoughts on all of this, but happy to talk about it in the Q&A. We might talk about how to rationalize legislative influence. In other words, if there are some contexts in which agency engagement in politics is required or even better than, so Barco has written a bit about how the value of structural agency independence may be overestimated in certain contexts, then maybe political influence should be infused with data, impact statements, and relationships with diverse legislatures and political perspectives. And then finally, we might think about when it comes to personal biases or governmental interests in administrative adjudication, one counterintuitive approach to this might be to reinforce independence. But other approaches could include, relying further on arbitrary and capricious review. Daniel and Poe and others have recently identified this as a possible pathway for condemning biased agency action, or even reinvigorating abuse of discretion doctrine to hold adjudicators accountable. So thank you, and I look forward to chatting.
Thanks, Bijal. So I think this paper is just an extension, I think, of your really important voice and point that you're bringing to the literature, which is to introduce critical theories, into the literature. And I think many times critical theories have been, mischaracterized, I think, as more like deconstructive rather than constructive. And I perceive you to have both kind of projects in mind, right? To deconstruct, many ways that people are thinking about traditional questions of administrative law. But I think you also have a constructive project in mind. And I think you're still working out like what that constructive project is. But I think some of the elements of it include, obviously a focus on quality, distributional impacts, asking about subordination and which groups are broadly defined, made better and worse off. And once you start to get to the constructive project, which I think is latent in this paper, I think that there are kind of bigger questions that you force us to grapple with. And because you're asking big questions, I'm going to my comments are also similarly big and kind of broad. So insofar as, you are discussing, kind of a substantive vision of quality, you use phrases like moral philosophy and so on. I mean, there are going to be, obvious questions about which institution is best positioned to instantiate that vision, right? Is it Bijal's vision of moral quality? Is it the courts? And I ask all of this because I think the most charitable understanding of functionalism is that it might argue, and again, there are functionalisms, but if we're going to take the core of it, that it would answer something like, oh, it's the democratic, democracy should decide what the relevant vision of equality, should be. And I fear that, particular ways of characterizing where this doctrine should go would end up constitutionalizing, particular visions of equality that would take away from democratic institutions, what those ends should be. Anyway, that's a big, huge set of questions, but it's just, what is the right institution to think about here? In this vein, and relatedly, and I think your talk really emphasized this, you want to push against what you call administrative self-interest, institutional interests. And I think it's worth thinking about, it's not surprising that I would say this, I think, but, is that, are we which aspect of the agency are we talking about, right? Because, civil servants have very different institutional interests. I think that's what you have in mind. You talk about budget maximizing, you talk about self-preservation, right? But that's different than the interests of the political appointees, which, some views would say they're the politically accountable ones. They're the ones, it's their visions of equality, that should carry the day. And that's just a very different view, I suppose, of institutional interest. Okay, 3 more thoughts. Another important theme in your paper has to do with a conception of liberty. Okay, you say, quote, a separation of powers framework in service of liberty must produce equity in order to adequately accomplish its goals. So I think there's a lot to unpack there. And I think one productive frame to think about it is just the old workhorse of thinking about in terms of Berlin's positive versus negative liberty. I mean, I think, you're kind of saying, I think that the literature is thinking too much in terms of negative liberty. And you think it's important to maybe have a vision of positive liberty. In order for people to be free, they need to have some of the, capacities and the minimum levels of equality to be free. So that might be kind of a useful concept for you to play around with as you continue this broader project. Okay, second, other big literatures to engage with, because I understand this to be a whole series of papers, is this huge literature on how to trade off between efficiency and equality, right? So this is all the debates about, we're talking Kaldor-Hicks efficiency versus Pareto optimality. I mean, many people have thought about this, and you're kind of asking this question, but in the administrative state, you're positing that administrative agents are advancing efficiency, and you want to trade that off with equality more. So I think that literature could be useful to you. Finally, in terms of your claims about, and they're empirical claims really, about who wins and loses under current functionalist approaches, I wasn't sure how to think about that because first of all, you cite some discrete areas of the law where you think certain groups lose, right? Like the environment, immigration, national security. But then there are lots of other areas where those groups might win, right? So think of all the agencies that like EEOC, and so on, that administer civil rights statutes and or are grant making agencies, right? They on net, some of these groups might be better off. And so like, how do we cash out, the who wins and who loses debates? And on this vein, and this is where I'll end, if your ultimate constructive project, is a particular vision of equality, we might just query, like, is separation of powers doctrine, like, really the right way to get there? I mean, there are probably much more important and effective ways of getting there. And here I'm thinking about all the literature and public administration on like representative bureaucracy. Like, why not talk more about like who's actually in these agencies and, would they better serve some of these ends? Okay, with that and an eye on the clock, there are 15 minutes left. Here's a suggestion for how to proceed, if only because I think this would be most useful to the presenters, is just to go through all the questions, get them all out, and then allow whatever's time left for the presenters to respond. I'm open to any other ways of doing this, but let's just try that and see how it goes. Okay, so I'll just open the floor for questions on any of these projects. Great, Rachel.
Thank you. Thank you so much to all the presenters. I have a question for Vijal. So I think this is such an interesting project. And I suppose I was wondering whether you're arguing against functionalism in general, or just whether you're arguing against a kind of specific type of functionalism that is one that's focused on administrative agency efficiency and institutional prerogatives as distinct from other goals like equity, democracy. And so couldn't we just sort of adjust functionalism in order to take account of those other normative considerations?
Jennifer, are we responding to each person, or how did you want to organize it?
Well, it kind of depends on the queue. So I just suggested, given the limited amount of time left, just to get all the questions out and then allow you to respond. Just we're very short on time, so there's a lot to do. Three of these in the hour and a half that we have. So okay, let me just get to the queue. Shalev.
Thanks. So I will again limit myself to one question, and it's just to kind of piggyback on Rachel's. I had a similar question about whether you're arguing against functionalism or just like bad functionalism or a particular type of functionalism, and would you support functionalism that just focuses, instead of on balance or whatever between the branches, that focuses on equality or anti-subordination? And in terms of your constructive proposals, this is I think basically the same question I had for you when I last saw you in DC. Like, how do you constructively battle the things you're opposed? If we accept the premise that law, serves to justify or re-entrench power dynamics, how would we construct institutions that do not just do that? And so you propose like maybe give agencies more independence from Congress. Why do we expect those agencies to use that independence for anti-subordination purposes? You propose a kind of statute-focused execution approach, but like, wouldn't we expect the statutes themselves to be entrenching these power dynamics? And so just kind of like, how do you grapple with those challenges? But so also, as you know, I think it's a super important and great project.
Thanks, Shalev. Noah.
So I just have a question for Christine, and it's trying to get inside the head of Congress. One of the questions that sort of always puzzled me is who you have in the government to do your work when you're trying to implement a government program. And I think Jennifer in her comments to you said, look, a lot of the descriptions of the sort of actual duties of some of the actors that the first Congress is invoking are people we would now think of as employees. And then I start thinking, wait, okay, and like at other moments in American history, you just don't have a lot of employees in the federal government. We might put them in an employee category, but certainly when we're thinking about something like Reconstruction, we just have to hire a bunch of people or use the army to do a lot of stuff that later you're going to fit into the category of civil servant. And then I think, wait, in all these categories, I'm applying, a sort of 20th century and 21st century framework for thinking about what a government servant is, which then throws me back on the first Congress. So in this era, I was always taught that basically, what we now think of as the sort of Prince anti-commandeering doctrine is probably directly opposite what people would have thought about government implementation at the founding in the early republic. That of course, federal programs were mostly going to be implemented through commandeering of state personnel. And so then I just thought, wait, okay, so what makes the particular pieces of legislation you focused on special? So that's the background. The question is, do you have a sense of who the first Congress was counting on to implement these various programs? And did they operate with a clear distinction between what we now think of as superior officers, inferior officers, employees, and then federal versus state? Or is there something more nebulous, especially in an era when you've got a lot of people working part-time for the government, including people we now think of as cabinet level officers like the Attorney General?
Thanks, Noah. Andrea.
For Bilal, so I'm sympathetic with the project and where it's coming from. I think like some of the other questions you've gotten, I'm not convinced that a more equity-oriented functionalism isn't the preferred solution. One thought I'd have is that in your paper, you define functionalism, I think, exclusively in a separation of powers context, separation of powers functionalism, as opposed to adjudication, right? Functionalist adjudication is adjudication that is sensitive to values. And then the question becomes, what values? Again, I think you seem to be saying that separation of powers functionalism is exclusively or excessively attuned to the value of balance, which itself can have regressive implications. So I wonder why not a separation of power, this has been said before, sorry, why not a separation of powers formalism that is attentive to inclusion, representativeness, equity, et cetera? Just that, thanks.
Okay, so on that note, I think Bijal, you have a couple of questions in the same vein. So why don't we go Bijal and then Christine, then Gerard, and just, we've got about 10 minutes left. Why doesn't everybody just take a few minutes to kind of respond to all the various questions that have been raised throughout. So go ahead, Bijal.
Yeah, so thank you all for your really thoughtful questions. You're the question that asks about, so in other words, as I was thinking about this paper, I too was asking myself, is what I'm saying that functionalism has in fact not been implemented appropriately or properly? In other words, it's not meeting its own goals or commitments? Or am I actually, bringing forward a critique of functionalism in some essential way that gets to the heart of and of course, much of this has to do with how we define functionalism, whether we think that there are various functionalisms or not, the perspective of functionalism that we're taking, whether we're focused on, like the commitments of adjudication versus a more generalized functionalism that's responsive to formalism. The thing I will say is this: to the extent that functionalists have gestured toward an interest in outcomes, equitable outcomes or outcomes that are sort of beneficial or that are like mindful of regulated parties, I don't think, one, that they have questioned whether the essential tenets of functionalism would in fact lead them to be able to privilege those stated preferences or interests. And to the extent that maybe they do see a tenuous connection between the two, I sort of ask myself, at what point does the fact that there hasn't manifested an actual relationship between these sort of values of function and the outcomes that functionalists are interested in, after a certain point, can functionalists claim that those interests are actually an essential part of functionalism? So I get the question. I haven't really answered whether what I'm saying, I think it's just, an important project to say functionalism could be a better version of itself. That's an interesting and important project. I think there might also be a point here or an argument here that functionalism, any version of functionalism doesn't get to the commitments that certain functionalists claim to have. And so it's something I'm still working with, but it's a good point. Yeah, Shalev, yeah, the last time, look, for what it's worth, this is a super early stage. And the last time I saw you, I had only come up with the kind of studies of functionalism, right? Like I hadn't come up with any suggestions as to the, like the functionalist or the equity focused separation of powers or, that whatever. So here's what I'll say, right? Like the fundamental idea that I have here is that to the extent that functionalism is overly concerned with its own function, right, with its own sort of self-preservation, maintenance, and proliferation, we might sort of piece by piece work through the aspects of functionalism that are particularly concerning and divorce or separate agencies from their self-interest, right? And so we can certainly quibble with whether or not the solutions I'm kind of coming up with are meaningfully meeting that goal, right? So independence from Congress, would that be better? I think that's actually similar to your question about whether statute. In other words, why privilege and enabling Congress over a sitting Congress? I think there's an argument to be made that, the kind of the harms and the kind of the political interests of sitting Congresses are salient and are particularly kind of in tension with the regulatory benefits or interests that agencies might otherwise pursue, right? But of course, you can argue that there's institutional bias and oversight built into statutes themselves. And so I get that. We can, if I had to choose one, I would choose emphasizing the enabling statute over the kind of like incidental and personalized political interests of overseeing legislators. But I think there's arguments on both sides of that. And then Andrea, yeah, part of the, part of the argument or part of the question I'm asking is like the sort of procedural aspects or the procedural emphasis of functionalism and the assumption, so that proceduralism, for instance, in the context of adjudication, the assumption that proceduralism is going to lead to good outcomes. I haven't spoken directly to that in this very rough draft, but I interpret your question as sort of getting to that. And if I'm wrong, there's certainly other ways to think about functionalism. You're right, outside the context of separation of powers. I'm targeting separation of powers functionalism purposefully, but of course, if I expand my idea of functionalism, I bring in legal realists, I bring in other, traditions, social science, then I can make different sorts of arguments. My point is to stay within the aspects of, functionalism, right? But to the extent I'm doing that, I do think that I have to contend with whether or not I think the procedural emphasis of constitutional and administrative functionalism is failing, because I think that's where functionalists would sort of point out the potential substantive or equality focused benefits of functionalism more than in any other aspect of functionalism. But all of these are great questions. Thank you for listening and for your feedback.
Great, thanks, Vijal. Christine?
Yeah, thank you so much for all the comments and the questions. So Noah, that's a great question. I think the overarching concern of the first Congress was that it was broke. It was looking for cheap bodies to help run the government. So a lot of appointments at the principal officer level were ex officio appointments. Every member of the Sinking Fund Commission already held another principal office. And same thing with patents. Thomas Jefferson, again, had to be a member of the patent board with 2 other principal executive officers. And I think that also continued to what you might think of as lower level decision makers. So pulling on board federal judges to be initial decision makers on factual issues for reducing the amount of penalties owed for non-payment of duties, for example, was, again, they were just trying to find bodies in the system that could do part of this work, but that they were unconcerned with having judges who could not be removed by the president play a role, I think is telling, right? That they're independent actors in the system playing this role. And I think especially to Jennifer's point about, were those judges just employees because they're engaged in fact-finding determinations? And I think the answer is no. I think if I could compare them more carefully to administrative law judges in Lucia, I mean, they did have power to conduct a hearing, right? Call witnesses, exercise that type of power that the Supreme Court recognized as enough to cross the line to be an inferior officer there. So I think maybe that might be an area of research I could play up more, is that that there were, at the beginning, we had Article 3 judges, district court judges, making some of these preliminary determinations. So you shouldn't be so worried about independent administrative law judges in our system today. And I'll just leave it there for final comments from Gerard.
Thanks. Great feedback for Jennifer, and thank you all for listening. I guess I'll just make 2 quick points. One is I like the point about the emphasis on institutional roles, or the difference among institutional roles, SG versus AG versus Supreme Court in Jackson's the sort of arc of his thinking, let's say, because in Youngstown he self-consciously talks about that in effect disavowing his views on executive power when he was Attorney General, which were far more loose and broad, and saying, well, okay, but that doesn't bind me now because I'm in a different role. So, I mean, I think that that's a nice sort of way to build on some of the things that the paper already talks about. I mean, the other thing, and it's more of a question I just have to contemplate a little bit, is, look, it can be a purely historical paper if you drop out all of the, well, how might it apply to a current controversy? And I might be forced into that in the sense that there is, in fact, legislation now pending in the Senate to amend the National Emergencies Act and eliminate the kinds of concerns that the paper expresses. So if that were to happen to pass, then the end of the paper kind of falls away. And then what you have left is a historical paper, which then draws more on questions like, well, to what extent should we go outside the 4 corners of an opinion, even a canonical opinion like Youngstown, to talk about it, and what about Jackson's role and his kind of how he was situated in the New Deal. So the paper may end up becoming basically a historical paper only, either without my choice or by my choice. So I will take that under advisement. So thanks.
Great. Well, that brings us to the end of our time. Thanks to all of our presenters, and I hope to continue some of these discussions in some of the other sessions and breakouts. Thanks, everyone.
Thank you, Jennifer. Thank you so much for your comments. I didn't get a chance to say it. Thank you.
Yes, thanks.
Appreciate it.